listening to the Agent Survival Guide podcast, a podcast for today's insurance agents. Informing, educating, empowering, improving the way you do business in an industry that's anything but static. In today's episode, listen as we unpack the Telephone Consumer Protection Act in How Health Insurance Agents Can Stay TCPA Compliant, written by Ashley Toomey. Imagine you're at home with your family, enjoying a nice meal after a long day. Suddenly, your phone rings. You check the caller ID. You're not familiar with the phone number. However, you are waiting to hear back from someone and you're not sure if it could be them. You answer and hear the upbeat voice on the other end of the line.
Good evening. I hope I'm not bothering you, but this is Jennifer Jones with Roof and Window Incorporated. Could I have a moment of your time to discuss how we can help you?
Ugh. You distinctly remember putting your phone number on the do not call registry. So you ask yourself, why am I receiving this phone call? It turns out that particular solicitor was not following telemarketing compliance regulations. As you know, solicitations are very important to the health insurance business. But there are many rules and regulations individuals and businesses must follow to avoid legal repercussions and general consumer discontent. A very crucial piece of one of these federal regulations all businesses, not just health insurance businesses, must follow is the Telephone Consumer Protection Act, or TCPA for short. And you know we love a good definition to start things off here on the show. So what is the TCPA? TCPA, or the Telephone Consumer Protection Act, is a federal law enacted in 1991 to regulate telemarketing calls, text messages, and faxes. It protects consumers from relentless and unwanted automated calls, texts, and faxes. Notably, it also places restrictions on the use of automated dialing systems for call and text, and pre-recorded or artificial voice messages. Insurance agents must adhere to TCPA compliance requirements. In fact, any organization or person soliciting business via phone or fax must remain TCPA compliant. There are several separate requirements that agents need to abide by under the TCPA. We will explore some of them here in this episode, but for all of the rules, you can read the full Telephone Consumer Protection Act, which is linked in our episode notes. Let's get into our list of requirements. Number 1, the hours insurance agents can make calls. Under the TCPA, telephone solicitations must occur between 8 a.m. and 9 p.m. in the client's specific time zone. Some states, like Florida and Louisiana, cut the time by an hour, so the window closes at 8 p.m. instead of 9 p.m. Be sure to double-check the regulations in the state your client lives to remain compliant before sending or making any telecommunications. That being said, despite the TCPA giving mandated call times, it is generally a best practice to call only during your individual business hours, so long as those hours fall between the TCPA's times. This reduces the number of complaints from consumers and is more respectful toward their time. Number 2, robocall and auto dialer requirements. If you're using an auto dialer, you must gain prior expressed written consent from a consumer before you contact them. To cover any foreseeable scenarios, it's recommended to write up a broad consent statement for your clients to sign. To ensure your statement remains fully compliant, be sure to add clear caller identification and calling hour instructions. One such example could be, I understand that I may be contacted via telephone, email, text messaging, artificial or pre-recorded voice messages, or automatic dialing at the contact information provided even if my number is currently listed on any state, federal, local, or corporate do not call list by, and then insert your business name. Then continue with, carrier data use charges and rates may apply. I understand that my consent is voluntary and is not a condition of purchasing any goods or services, and that I may change my preferences at any time. Feel free to adjust any language or add in any other particulars that would be beneficial for you to clarify while running your insurance business. And please note that this disclaimer example is not inclusive of all disclaimer requirements that may be required. Further regulatory requirements may apply depending on the industry you are operating in. Now, you might be wondering what counts as auto-dialed under the TCPA. Any calls or text messages made with the use of an automatic telephone dialing system, or ATDS, fall under the auto-dialed designation. Number 3, outbound mass text messaging. Automated mass text messages can be sent out to multiple clients for ease of sending the same message out to many people at once. The law stipulates that after most of the text message has been relayed, it should also provide opt-out instructions in a bold typeface. A good example would be reply stop to unsubscribe with stop in all caps. If a client asks to opt out, you must remove them from all future mass text messaging within 10 days if removal isn't already automated. Number 4, outbound artificial or pre-recorded voice messages. When using artificial or pre-recorded voice tactics for your outbound messages, you must first state your registered business name, especially for clarity to your clients. Being as transparent as possible with clients is not only an effective way to stay compliant, but also to build trust with them. In addition, if the message has an advertisement or a telemarketing message, it must provide an automated opt-out mechanism, like with an interactive voice or key activation option. That way, if the client does not want to participate in these types of messages, they can automatically opt out without your intervention, and you remain compliant with the regulation. At some point in the message or near the end of it, you must also state the phone number of your business that, if called, must also provide an option to opt out of future calls. If your message happens to only reach voicemail, it must provide a toll-free number for any future automated opt-out requests. Number 5, the Do Not Call Registry. In 2003, the Federal Trade Commission, or FTC, created the Do Not Call, or DNC registry to allow Americans to opt out of receiving most telemarketing calls by adding their phone number to the registry. It is strictly prohibited to make any telephone call or message made for the purpose of selling a service or goods to the phone numbers on the registry unless they meet one of 2 exceptions, and we will get to those shortly. The FTC notes the registry only features phone numbers. There is no way to indicate whether the number is a landline or mobile phone. No additional personally identifiable information is available through the DNC registry. According to the Telemarketing Sales Rule, or TSR, businesses are required to scrub their call lists against the DNC at least every 31 days. If you're looking for lead scrubbing services that could help you remain compliant with this regulation, Integrity Connect leads are already scrubbed against DNC lists. If you're not already using this cutting-edge tool, check out the details with the link in the episode notes. Now, let's talk about those DNC exceptions for calls. The first exception occurs if the client provided a prior expressed invitation or permission to receive such calls from you. So, for example, a client completes your business reply card or an online form. The second exception occurs if the client has an established business relationship with you and That person has not previously informed you that they do not wish to receive calls. And the FTC considers an established business relationship to exist between you and your client if the client has transacted business with you within 18 months prior to the call. A business relationship is also considered established if the client has made an inquiry or application regarding products or services offered by you within 3 months prior to the call. It's important to note that if you do not have expressed written consent or a business relationship with your client, you are legally required to scrub their number against the DNC registries. Cold calling is also strictly prohibited in Medicare business, even if the DNC is scrubbed. Number 6, consumer opt-out requests. If your client makes any request, whether it is written, auditory, or electronic, that can be reasonably interpreted as a request to not be contacted in the future, that request should be treated as an opt-out from future communications. An example of a request could sound like, I would prefer not to receive calls about this. Hopefully all the ones you get will be that polite. When receiving one of these requests, they must be excluded from any future communications and should be maintained in an opt-out log. Once received, a request to opt out should be implemented within 10 days of the request if the process is not automated. Number 7, consent on file. You might be asking yourself, what should I do if I'm not sure if there is an appropriate unrevoked consent from my client on file? Please make sure you avoid using an automatic telephone dialing system, any pre-recorded or artificial voice calls or text messages, and scrub their number against the DNC registry. And I did mention this before, but I will say it again. Cold calling is also strictly prohibited in Medicare business, even if the DNC is scrubbed. Now, let's talk about some of those states with mini TCPAs. Some states have stricter regulations than others. These rules are more commonly referred to as mini TCPAs. Just as some states cut the call window an hour shorter than others, these states impose stricter requirements based on each state's individual laws. Some examples include California, which requires telemarketers to register with the Attorney General and mandates additional disclosures during calls. Florida requires explicit consent for all telemarketing calls, including manual calls, with severe penalties for violations. Here in Pennsylvania, the home of Ritter Insurance Marketing, telemarketers are required to register annually, and they must comply with stricter state DNC rules. And the last example I'll mention, in New York, the state mandates written contracts for certain telemarketing transactions and restricts certain call times. And just a quick note, this list of state-based rules is not exhaustive. It's just a sample of select states and some of their specific requirements. Now, you might be wondering, is the FCC one-to-one consent rule in effect? No, the Federal Communication Commission, or FCC as we refer to them, proposed a one-to-one consent rule, but it did not take effect. This FCC proposed rule, also known as the lead generator loophole, would have required a separate consent for each company contacting a consumer through a robocall or text. The FCC's proposed legislation was struck down and put on hold indefinitely on January 24, 2025, by the 11th Circuit Court of Appeals. Now that we've worked through our selection of requirements, rules, and regulations, let's talk repercussions for non-compliance. If you don't remain compliant with TCPA regulations, you could face quite a few consequences, including steep fines ranging from $500 to $1,500 per call or text, lawsuits and class actions from perturbed clients, damage to your business reputation, legal fees, and regulatory scrutiny. To avoid any substantial financial, legal, or reputational repercussions, it's important you take the TCPA texting and calling rules seriously. And for a comprehensive list you can check off as you go, helping you stay compliant with the TCPA, don't forget to visit the episode notes. We have our TCPA checklist available for agents to download. Federal and state regulations can seem intimidating at first, but we're here to help break down the rules specifically for our industry. And hopefully this episode has helped you feel more confident in telemarketing insurance compliantly. Here at Ritter Insurance Marketing, the FMO that powers this podcast, we are passionate about compliance and helping agents stay up to date with the latest information. If you're not already partnered with our FMO, we will have the link to register on RitterIM.com, and then you can check out our tools and resources for yourself. Thanks so much for listening to this installment of the Agent Survival Guide podcast. We will see you next episode. The Agent Survival Guide podcast is a production of Ritter Insurance Marketing, an integrity company. This episode was written by Ashley Toomey. Script proofing by Emily Ryan. Podcast design by Urban Rivera. Artwork by Tina Lamoureux. Recording and production by me, Sarah Ruppel. Rate and review our show on Apple or Spotify.